Hello, everybody. Welcome to the Loud Little Ducky. I am going to attempt to do part two, and hopefully, my mic does not act crazy because it works on another program. So I don't know what the deal is. But part one, we were reading through Gingras Motion to Quash for Owens versus Hey Rob. And we got through some of it, but not all of it before technical difficulties. And we do know Gingras was allowed to represent Owens in this matter in the hearing on Friday. So before we get a decision, because we haven't gotten one yet, I want to finish going over this so we have all context before the decision comes out. So let's bring that up. Right. Sorry. All First Amendment lawyers, hello, Bruce, understand that at least when they involve celebrities and general public purpose figures, the First Amendment usually protects jokes, parody, even if rude and disgusting. See Hustler v. Fella. I think we read this the last time, but I'm going to start with it. So, finding First Amendment protected offensive parody involving a famous public figure. Miss Owens is neither a celebrity nor is she a general purpose public figure. No, she is a limited purpose figure, just like Karen Reed. Some people would think that Karen Reed is a public figure because of her case. Laura Owens, similar. This matters because when plaintiff is not a public figure, the protection provided to speech by the First Amendment may be much lower or even non-existent. The U.S. Supreme Court and Arizona courts have also held harassment and threatening conduct may not receive any First Amendment protection at all. True, threats of violence are outside the bounds of the First Amendment protection and punishable as crimes. And then he puts State v. Snyder, which we can look at later. Recognizing harassment is not protected speech, obviously, but nobody's doing that. Let's see if we can make this a little bit bigger. In addition to publishing the above comments, Hey Rob has done much more. As explained in Miss Owens' petition, Rob recently, on January 14, 2026, published a video in which he encouraged viewers to locate Miss Owens by contacting places he believed she might be. He italicized that. And by falsely impersonating her, in effect, to verify her location. He doesn't know that he did that. Describing an incident on 1/14/2026, Rob has also made threatening, demeaning, insulting, sexual statements about Miss Owens, stating he believes she belongs in prison. Yeah, most people believe that she belongs in prison. And that guards there will arp her in the butt. Well, I hope that doesn't happen, but things also happen. While also referring to her as a contour. Okay. It's not a nice name, but oh well. Describing incident on 11/11/2025, Rob has further described following Miss Owens to virtually every court hearing she has attended. He has not followed her to her court hearings. He doesn't go to the casita, wait till she leaves her casita, and then follows behind them to court. No, he just goes to her public court hearings. You make this sound awful, and that is not the reality of this situation. Let's see. While expressing a desire to fucking bitch slap her through the phone. Well, most of us wanna do that because none of us are there in person. Based on these and multiple other harassing acts, Owens sought an injunctive relief from this court, which was granted on January 20th, 2026. I hate that she's like, and my motion was granted when I got this temporary order. Yeah, all temporary orders are probably going to be granted, and then they can be taken away when you have to prove your stuff. So, and it was granted based on a one-sided story, it was granted. Just like when you go to a grand jury, there's no defense there. It's just like, yeah, we think you could charge somebody with these facts, not knowing any of the contradicting facts. When you hear a one-sided story, yeah, it's gonna sound that way. And then you're like, "Hold on a fucking minute." Rob now challenges the order on several grounds, as is his right to do. As explained below, Rob's arguments are not just without merit. They are at best frivolous and at worst intentionally misleading, if not outright fraudulent. And your client has never done anything fraudulent in a day in her life, has she? Accordingly, the court should affirm the harassment injunction in its entirety. Hello, Rob. I hope you're holding up very good. Let's see. The court should also order Rob to pay Owens reasonable attorney's fees and costs in an amount to be determined later. Nobody wants to pay your fees and costs, Gingras, for all your pro bono work. No, you want to represent her for free? Then represent her for free. She's the one that files things. Rob didn't ask to be here. I think if you've decided to work pro bono on a case, I don't think you should be able to ask for attorney's fees. You did this out of the kindness of your heart for the needy, right? You don't get attorney's fees. Finally, given the extreme circumstances of this case, in light of the evidence showing Rob has continued to violate this court's order after it was served, he has not violated the order. He has not violated any. He has not contacted her. He has not been near her. None of that. He is allowed to say her name and talk about his situation. The court should refer this matter to the Maricopa County Attorney's determination regarding potential criminal charges to be brought. There is no violation on this. Such charges, among other things, violations, use of an electronic communication to terrify, intimidate, threaten, or harass. He has not communicated with you. He has not tried to terrify you. He has not tried He has not threatened you, and he has not harassed you. He has simply said, "Hey, this is what is happening." And he's allowed to do that. It's not felony aggravated harassment. It's not criminal harassment. He's not stalking her. There's not knowing perjury, among others. It's not perjury when she says that he said something in a video, and in that video, that thing is not said. That's not perjury. If somebody was like, "Oh, in this video, they quoted all this," I would go back and watch that video because I'm like, "I don't think I said that, or did I say it? Did I say it that way?" Like, no. How is he supposed to know, "Oh, he said it in a different video and he should have known," and whatever. That's not how this goes. Rob's motion raises three primary arguments in his defense. The first is factual argument, while the other two are legal. Okay, well, he's allowed to do that. Don't you be bringing factual things to court against Laura. She didn't bring her factual facts to court. Number one, I didn't do it. I didn't do some of it. Sorry. Rob denies making some of the statements attributed to him by Laura. As explained below, this argument is at best intentionally misleading and at worst may constitute perjury. So you're like charge him with perjury, even though it may constitute perjury. In short, Rob made every statement he is accused of. To the extent he has denied this in a sworn declaration, the evidence appears to show he committed perjury in making that denial. No, he didn't. He said it wasn't in that video that she said it was in. He says, I didn't contact her directly, so that's not harassment. Hey Rob's second argument is purely legal. Okay, he's allowed to make legal arguments, i.e., that. Sorry, just a minute, guys. Okay, sorry. Sinuses. Let's see. The Arizona harassment law requires the defendant have direct contact with his victim before relief may be granted. This argument is a clear material misstatement of the law, which this court must firmly reject. Um, and I hope he explains. 3, even if I did it, the First Amendment protects me. As a final point, like many other defendants before him have unsuccessfully tried to do, Rob seeks to hide behind the First Amendment. While he is entirely correct, the First Amendment provides broad protection for speech. There is no question that protection is not unlimited. Yes, we know that the First Amendment doesn't cover everything. Based on this extensive legal argument cited below, it is clear that Hey Rob's words, deeds, and actions fill for outside even the most liberal application of the First Amendment. Oh, his act fall far outside even the most liberal. Each issue is explained further below. Thank goodness, I guess, so I can tell you you don't know what the fuck you're talking about once again. Rob made every alleged statement. In his motion and supporting declaration, Rob accuses N- Laura of lying to this court about what he said. On that much, he does not mince words. Contrary to Owens' mischaracterizations and outright fabrications of what Rob actually said, nothing in those live stream videos meet the criteria of ARS 12-1809. Because this presents a factual dispute, it is not appropriately raised or addressed in the context of a dispositive motion. However, for the court's benefit, it is important to explain one thing as clearly as possible. It appears Rob committed perjury in his declaration insofar as he denied under oath making certain statements. This is a serious allegation, so let's be extremely specific. Using just one example in paragraph 22 of his sworn declaration, shown below, Rob claims that Laura falsely accused him of making several violent and offensive statements. He quotes each of the alleged comments and then denies making any of them, asserting the statements appear nowhere in the transcript, either at the time claimed by Owens or anywhere else in the transcript. He even goes further, stating the quoted statements do not appear in any other live streams Owens cites for that matter. Well, maybe she didn't cite the video that those state, even if they are in other videos, if she didn't cite the videos that they are in, he's not lying here. So I don't know if that is the case. Okay. Owens falsely alleged during the live stream at this timestamp. I said, if she goes and says, I'm indignant because the court said so, I'll fucking bitch slap her through the phone, through the camera, wherever I can get her. This statement appears nowhere in the transcript or in any other live stream Owens cites for that matter. See Journal Exhibit 5. Owens alleged that I made other statements that appear nowhere in the transcript, including she's a fucking twat, she's an a-hole, she's a cunt, and recently a bloody ass cunt, okay? These do not appear at the timestamps she cites or anywhere else in the transcript. Okay? They're not in the transcript. Well, if they're not in the transcript, they're not in the transcript. Did he it that Owens cited? Unfortunately, for Hey Rob, Owens kept receipts, and those receipts show two things. First, Rob did in fact make every statement Miss Owens has cited. This is not an opinion, it is a fact, and can easily be verified by simply viewing the video, which will be offered in evidence at the hearing, and which is available here. I'm guessing they possibly showed this video at court Friday. I don't know. In this video, contrary to his sworn affidavit, Rob recorded himself making the following statements at the following timestamps. Okay, but he said in the transcript, nowhere in the transcript. He didn't say it was nowhere in the video. He just said it wasn't in the transcript. That's not perjury. If it's not in the transcript. So then he says, she's all these words. Thus, contrary to Rob's sworn denials, he did in fact precisely make the statements Owen cited in her petition. Okay, but are they from the video she claimed it was from? And was that in the transcript? Because maybe he didn't watch the video, maybe he just read the transcript, and maybe the transcript didn't pick that up. That's not lying. You have to show that he knowingly lied under oath. Based on this, it appears Rob knowingly lied under oath when he denied making these statements. Footnote 3. Let's see what footnote 3 says. In fairness, Owens did mistakenly attribute some of these statements quoted in her petition to the wrong source video. So how is that perjury when she cited some of the wrong statements to the wrong videos? That's not perjury. That's him looking at a video that she said something was in, and it wasn't in that one. It's not him lying. Unlike saying that you went to Planned Parenthoods that you never went to, that you apparently, um, had sonograms when you didn't, that your dad touched your pregnant belly when he didn't. Those are knowingly false lies. When you have to say he committed perjury, but to be fair, Miss Owens didn't say the right things, then it's not perjury. Your client was mistaken. He didn't say he's never said those things ever, and you won't be able to find anywhere that that happened. He never said that. Right. They're the ones to talk about perjury. Are you kidding me? I mean, she committed more perjury in her bankruptcy thing the other day. Petition in the wrong source. Owens' petition claimed Rob made the bitch slap statement, among others, in a video titled Trial LOVMM, Travel Granted. See petition 5, incident dated 11/6/2025. This was a simple clerical error. Yeah, she miscited the video. So if he goes and looks at that video that she said he made these comments in and it's not there, he's like, "What is she talking about? I didn't say that anywhere in here." The quoted statements do not appear in that video. They appear in another video. Well, then you needed to tell him which one it was so that he could go review it. But you didn't tell him that. And then he says it's actually in the LO versus CE judgment debitor examination filings, which is linked above. Okay. So how is he committing perjury when it just says it's not in the transcript of that particular video? The fact is incredibly ironic given Miss Owens has been charged with perjury. And although she's not been convicted of any crime, Rob has posted hundreds of videos calling her to be convicted and sent to prison. Yes, it's not necessarily because of her perjury that we want her sent. It's her it's her lies and her scheming of men. It's the scheming of men. She can lie about it all she wants, but she can go to prison for it too. Although she is not okay, we already said that. Okay. He has also laughed about her being arped in the butt while incarcerated. Sometimes we have to laugh at this shit because it's extremely sad. The irony and the boundless hypocrisy cannot be overstated. Oh my God, you're so hyperbolic. In any event, Rob's first defense, denying that he made certain harassing statements identified in Owens' petition, is entirely groundless. No, he's saying he didn't make those statements in that video. B, Rob misstates the requirements of Arizona law. Second point raised by Rob is a legal argument required or regarding the statutory requirements of ARS 12-1809 T1A, which defines harassment as a series of acts directed on or at a specific person. According to Rob, videos posted on social media cannot meet the definition unless the defendant sends them to his victim. First, although Rob's YouTube videos are about Owens, they are not directed at her. Right. The law's requirement that harassment be directed at the plaintiff means the statements made to others do not qualify, even if the plaintiff becomes aware of them. And then he cites motion and all that. So let's continue down. This argument materially misstates the law, putting aside the fact LaFaro involved events which occurred in late 2000s, more than a quarter of a century ago. The case did not involve statements published on social media. YouTube and Instagram did not exist when LaFaro was decided. Rather, LaFaro involved verbal public statements made by a political candidate to a small crowd in front of a Tempe public library at a polling center. Okay. Given the ethereal and limited nature of the words spoken to a small crowd, which are not remotely comparable to videos posted on social media, which remain visible to an unlimited number of people forever, the Court of Appeals held verbal comments of this type did not meet statutory requirements of ARS 12-1809 because they are not directed at the plaintiff. Okay. They're not directed. This holding does nothing to help Rob. This is so because in the quarter of a century since LaFaro was decided, the Court of Appeals has established entirely different rules for dealing with people like Rob, who use social media and the internet to harass, stalk, and terrorize others. Thus, although LaFaro remains valid law, the case in strict limited to the facts it presented, i.e., verbal statements made offline to third parties, do not meet the directed at requirements of the statute. This rule has no application here. Yeah, it does. Here's why. In State v. Snyder, 2024 case, the defendant was charged with criminal harassment based on social media posts he made about the victim, an ex-girlfriend named Bibi. After Mr. Snyder was convicted, he appealed, raising the exact same legal argument. Hey Rob offers here. Example, that because he only made posts about Bibi, but did not send them directly to Bibi, his conduct was not directed at her, as the statute requires. Snyder argues that the state failed to prove that he contacted or caused a communication with Bibi between June 1st, 2018 and August 1st, 2018, because he did not directly send Bibi any messages while her order of protection was valid, and Bibi only became aware of his social media posts concerning her when third parties had shown him to her. He did not directly send any message while the order of protection. Okay, so he didn't send them while there was an order of protection against him. I would like to know what the order of protection was. The Court of Appeals flatly rejected this argument and affirmed the criminal conviction. In doing so, court explained that when a defendant posts statements about a person on social media, the victim learns about those posts through other means. That meets the statutory requirement for acts directed at plaintiff. First of all, this dude was under an order of protection when he did this. Hey Rob, when he made his statements, was not under an order of protection. So, not the same. They're not in the same situation. So, they're two different things. There is substantial evidence indicating that Snyder's conduct was directed at Bibi, including him posting a video on his social media account that showed the order of protection with Bibi's name and address on it. Snyder also argues that no contact occurred between him and Bibi after the order of protection was served on June 1st. But under the statute, a person commits harassment if the person contacts, communicates, or causes communication with another person by verbal, electronic, or written means in a manner that harasses. He doxed her address and her name if people didn't know it. He doxed her. And maybe people knew who this BB was prior, but maybe they didn't know her address. These are not the same situations, Gingras. Emphasis added. Again, the court must stop and consider something astonishing. The defendant in Snyder was convicted of a felony aggravated harassment. Yeah, Rob hasn't been convicted of anything. A conviction later affirmed on appeal because after he was ordered to stop harassing the victim, he posted a video on social media showing an order of protection with the victim's name and address on it. Want to guess what occurred after the court ordered Rob to stop harassing Owens? He committed the exact same felony as the defendant in Snyder. What's funny is he posted, yeah, it says injunction against harassment, and he didn't post it. Lauren posted it. So, no, not the same exactly. Also, it has her name. Her name is known to the public. So that's it. And her address is nowhere to be seen on this. So, not the same situation once again. Why are you such a dumbass? E Exactly. And they've had contact with each other in the past. There is no contact that has been had in this thing. I mean, she admits it. They've been in the same room at a time. Snyder is not the only Arizona case to reach the conclusion. For instance, Raber v. Wagner involved a defendant who was accused of harassment by sending texts and emails to the victim's friends, relatives, work colleagues, and other contacts. The speech in question was extremely tame compared to the disgusting vile remarks made by this. Yeah, because it states in there that you are not allowed to have third-party communications, which means you cannot contact the person's friends or people that they know to reach that person. Like, Rob can't contact Laura directly, which he never has, but he also couldn't try to contact her sister to get a message to Laura. Or he couldn't try to reach out to the guy where she stores her horses and get a message to her that way, which he hasn't done. This is ridiculous. The speech in question was extremely tame and blah, blah, blah. Nevertheless, the Superior Court found the defendant conducted sufficient to support an order of protection. I'm not even a lawyer and I can argue against you. The Court of Appeals affirmed in doing so. The court clarified that notwithstanding LaFaro, the electronic means are used to harass. Direct victim contact is not required. Yeah, that's why they say, and no third party. In so holding, we take no issue with our previous decisions that have vacated protective orders on the grounds that a defendant's communications were directed towards third parties rather than directed to the victims. Yeah, but that's listed in the stuff you're not allowed to do. Again, these points demonstrate that Hey Rob's arguments are not only groundless, they are frivolous. No, it just means that you don't understand law, Jingras. This justifies affirming the existing order and granting Owens' request for attorney's fees. It also warrants referring Rob to the county attorney's office for criminal prosecution, exactly as occurred in Snyder. Snyder was under a felony indictment, first of all, and had been convicted. There has been no charges for Rob. The First Amendment and Arizona Constitution do not protect criminal harassment and similar crimes. The final point raised by Rob is a second legal argument that his conduct is protected by the First Amendment. Notably, Hey Rob does not cite a single case from the Supreme Court or anywhere else. Usually, when you're citing to the First Amendment, you don't need to cite to anything else because the First Amendment is what you're citing to, and it's like the ultimate cite, which held criminal harassment is protected by the First Amendment. That failure is hardly surprising, given the U.S. Supreme Court has repeatedly agreed, provided the appropriate mental state, recklessness, is shown, harassing threats can be punished civilly and criminally in a manner consistent with the First Amendment. Okay, good for you. Counterman versus Colorado, a 2023 case establishing recklessness requirement in a criminal case where defendants sent threatening Facebook messages to the victims, such as "fuck off permanently." Rob hasn't sent any Facebook messages or any type of messages like that to your client online. Staying in the cyber life is going to kill you. He's not contacted her in that way at all. So this case doesn't relate to this case. It's not relevant. Consistent with U.S. Supreme Court precedent allowing for criminals and civil punishment of harassing speech and conduct, Arizona courts have repeatedly explained harassment is not protected speech. Well, none of that's happened here. So, agreeing harassment is not protected speech in these other cases. To understand this conclusion, this court need only consider State v. Williams, which involved facts nearly identical to those here. They probably don't because you never cite cases that are relevant. Williams involved a photographer who harassed a model primarily by posting comments on her social media. After the victim obtained a harassment injunction, the defendant continued making comments about her online. If he is posting on her page, then yeah, that's contact. Rob is not posting comments on her social media page. The defendant continued making comments about her online, referring to her as a fraud and a real P actress. The defendant also posted a statement about the victim on his Facebook page, accusing her and the judge who had granted this injunction of ethical violation and stating, "I can't wait to see you in an orange, and your judge will be your cellmate, I guarantee." Okay, so this is bad, saying, "I can't wait to see you in orange and your judge will be your cellmate, I guarantee." But what you say about Judge Mata is just fine. Hypocrite much? Yeah, nobody's contacting her. Hello, South Florida. Hello, Batty McBatface. It's just there. Yeah. Uh-huh. Filing an injunction against making me groan. Exactly. Bruce is filing one for making me eye roll too much. He just gives me a headache. And so I'm gonna need to sue for that. Yep. We don't like Laura that much, but we're not doxing her. All right. So he can say things about a judge and stuff like that, but nobody can say anything else. No, I didn't. I have not seen that. You can't say stuff about people like this. But he'll be like, "Well, Judge Mata doesn't have a restraining order against me, so I'm allowed to say things about Judge Mata." Yep, she went looking for it, but Natty James apparently she also backtracked this statement and said that somebody told her. about it, and that's why she went looking for it. But she looks at all of our content, so alright, so let's see here. These statements are virtually identical to the types of comments Rob has made about Owens, with the main differences being the volume of content, which is far worse. Considering this, the defendant Williams posted a tiny fraction of the amount. It doesn't matter. None of what he posted was before that. That's it. Rob has created targeting Owens. Despite this, Williams was convinced of harassment and sentenced to 175 years in prison. Okay. Rob's not being convicted of anything. Oh. Mommy Gingras saw him in action in the court, according to his blog, so he's changing his position on Mata's dad attending. Oh, Lord. Might have to look at that. Okay, once again, these are all, like, people that have been criminally charged for things, and they're doing things after they've been criminally charged. Not the same scenario. The statements are virtually okay, we've already read that. Okay. On appeal, the Court of Appeals rejected every argument raised and affirmed the prison sentence. Yeah, Rob's not getting a prison sentence. And Mommy Jingras should be embarrassed about her son. Because I would be if my son did stuff like this. And I have no problem calling out my son. I tell his girlfriend, I'm like, you just call me if you need me to put him in line. Because no. Let's see. This dude made the argument, or Williams asserted that he had a constitutional protected right to use social media as long as he did not contact her or engage in unprotected speech. The court's response, no, he did not. Not when you have things and he's going on her page, because going on her page is contacting her. But we're making these on our own things. We're not contacting anybody. We're not sending anybody a link to anything. Like, she literally has to go look for this stuff. Because in even Googling her name, maybe on Rob's Google searches, he pops up. When I Google the names, other stuff pops up. She wouldn't even find it doing a Google search. Like, she specifically has to go look for this stuff. It's not just an easy find to those things. There's no reason for this court to reach a different conclusion. Rob's actions are clearly criminal violations of Arizona law. If anything, Rob's conduct is far worse than any of the examples cited above. Well, considering Rob doesn't know, like, they don't know each other in real life, no. This court properly determined as much when they ordered Rob to stop harassing her. Well, he hasn't been harassing her, so despite that order, Rob did exactly what so many other stalkers and harassers have done. He simply ignored the court orders and continued harassing Owens exactly as he did before. Not true. You're lying right there. Like the defendant in Williams, Rob is not engaged in protected speech. He's committed and continues to commit serious criminal violations of Arizona law, including, it appears, perjury in the course of pleading he filed in this matter. No, because you proved by your little footnote that it wasn't perjury. Every person may freely speak, write, and publish on all subjects, being responsible for abuse of that right. Arizona Constitution, Article 6:6 Conclusion, Rob's motion should be denied, and the court should award Owens her reasonable attorney's fees and costs. The court should further refer this matter to Maricopa. They just want to have a referral because Laura was referred. Which, no, we're not doing that. He always speculates. Like, this is not helping Laura's criminal case by them to continue to do this bullshit. Like, if they're speculating about Planned Parenthood, all he's doing is making her criminal case worse. And let's take this down. Do not forget to like, subscribe. Make sure you comment if you're on Replay Crew. I love you, Replay Crew. And all that good stuff. But tomorrow, Corey Richards' trial starts. And that one is out of Maricopa County. Just as the Lori Vallow and Charles Vallow one, and Brandon, why is his name? I can't remember. It's Brandon something, and I cannot think of what his last name is for the life of me for right now. But those were in Maricopa County as well. But tomorrow, Corey Richards is in Maricopa County, and Rachel Mitchell has made comments and stuff about it as well. So that'll be a good one to watch. All right. And then so he cited Stevie Snyder. Let's see here. Cite the facts. Contacting. Okay. Discussion. Judgment of acquittal is appropriate when there's no substantial evidence. Such person commits harassment if intent to harass or with knowledge that the person is harassing another person anonymously or otherwise, contacts, communicates, or causes a communication with another person by verbal, electronic, or written means in a manner that harasses. I have to read that later, but the Snyder one to me is different. And let's see, but the Florida statute applies. The defendant sends or procures the sending of communication. So Arizona, I have to read that separately. All right, let's see what new shit Jingras is talking about. It's literally called "Look at Me, Mommy, I'm a Real Lawyer Now." I thought y'all were just putting that in the comment. He really labeled it that? Oh my God. What in the... And so, okay, so we'll read that in just a minute. But like I said, there was no ruling yet. Um, Laura did attempt to get emotional or did get emotional apparently during um during her testimony. Rob did not testify, but Laura did. Gingras represented her. Let's go over the rest of these things. All right, so let's go over these rulings. Yeah, she does. When she's getting questioned, she just runs out because she just starts bawling because she doesn't know what to do. She was doing it. She's done it in the bankruptcy hearings as well. I'm sure she did it in her deposition, and I'm sure she's going to do it in her bankruptcy deposition as well. All right. I don't know how to embiggen this, so I am sorry. Let me see if I can change the view for y'all. Hopefully that's a little bit better. All right. So, Judge Coates was going to take it under advisement. She was going to attempt to get a ruling out by the end of the day. She didn't, so we might see that tomorrow. And is taking a hard look at Laura's history in the courtroom. Rob's team successfully pushed for judicial notice of the following findings from the prior Mata paternity case, which is probably why David wants to bring up Mata again, because Mata was the start. It's not really the start, but they blame Mata for the start of their problems and JFC because it could never be their problems. So he needs to talk about Mata again because it's being used against Laura again. So they need to talk about her. The calculated scheme, the prior court found Laura engaged in a calculated and malicious scheme to include falsified evidence. The not credible, Judge Coates noted for the record that Laura was found not to be credible in the proceeding. I'm thinking she's saying not credible in the Clayton v. the Owens v. Eckerd case. I don't think she was saying she wasn't credible in this proceeding, in that proceeding. The oral sex claim, the court specifically noted the finding that she claimed to have become pregnant. I don't know why that particular one is necessary. Like, is why we talk about her, and it shows that she's a liar. And then the perjury referral, it was noted that her prior testimony resulted in a referral to Maricopa County Attorney's Office for potential perjury charges, which the judge is probably like, why is this doofus sitting here saying, refer him to prosecution, refer him for prosecution, because most people don't say that in things. And so she's probably like, oh, she got referred for prosecution. So now they want everybody else to be referred for prosecution. They talked about the horse shows versus medical emergencies, that there was significant back and forth about Laura's attendance at a California hearing. And that, in Laura's declaration, she stated she was deathly ill and had a life-threatening condition that prevented her from attending court. The receipts were Rob's defense pointed out that she attended a horse show just 5 to 7 days after filing the declaration. It wasn't even, well, after she filed the declaration, yes, but pretty much the day of or a day or two after the court thing happened. So it doesn't even matter that she filed that 5 to 7 days prior. It was that she had said to the judge on the same day or a day or two before, not even 5 to 7 days, that she couldn't do it, The defense, her attorney Gingras, argued that she didn't skip court specifically to go to the horse show, but Rob's side used this to challenge her medical excuses. Yeah, you're not deathly ill and having life-threatening things if in a week you can go do these things. Privacy and public records. Laura alleged that her private medical information, autism, epilepsy, and anxiety was leaked and speculated on by YouTubers. Nobody leaked that except for Laura and Jingras. The counter argument is Rob attorney countered that this information was already a matter of public record because Laura herself brought it up during the paternity case. Yeah, and her Medium blogs. Laura is seeking to make the injunction against harassment even stricter. Her request includes a 500-foot stay away order and banning him from attending future court hearings. Her lawyer argued Rob's presence is meant to scare her. No, it wasn't, because she didn't even know he was there, who he was when he was there. So it wasn't meant to scare her. Attorney's fees. Laura's side is requesting that Rob cover her legal costs. The harassment debate, reporting versus harassing. Rob's attorney, Matthew Kelly, argued that Rob is simply reporting on a person currently facing 14 felony counts, fraud, perjury, and forgery. And First Amendment, the defense maintains that reporting on a public court filing and indictments is protected speech and doesn't constitute as harassment. Exactly. So we will see what happens with that. And the thing is this is not a, yeah, she leaked. She leaked the story about the paternity thing. She leaked her medical issues. She leaked everything. It's just unbelievable. But the thing is while this could set a dangerous precedent for people online, or maybe I wouldn't say a dangerous precedent. I would say it's going to set a bad precedent, because if this goes through, this is going to mean that if you talk about somebody and he says Rob's basically talking to nobody, right? Because nobody watches him is what he says. So apparently if you're even talking to yourself, if it somehow is found or your person goes looking for things, then you can be charged with these things. And if she's able to get away with this based on if the ruling is just, it is agreed to and she gets to keep it. If she doesn't write in there based on the comments and stuff, I do not grant it for that, because that is the First Amendment, but I do grant it for this. That's gonna be a little bit better. But if she just straight grants her motion and doesn't explain anything, she could come after every single person that has ever talked about her, which is what Gingras and them wants to do, is a class action lawsuit. She wants to sue a whole bunch of people. And so, that's not gonna be good if she gets that leverage and power. She is not somebody that needs that. And so I can I could see her saying, it wouldn't surprise me if it got approved for him not being able to go near her. If it got approved for just that part, okay. And he can't directly reach out to her or anything like that. But the judge should also say, he's allowed to speak his mind. He's allowed to talk about a public case. We can't do future prior restraint on future speech, whatever it said. And if you don't want to know what other people are saying about you, don't go looking for it. So, but there's been no threats. And hopefully the judge sees it that way, that those aren't threats. But if she grants it just based on, hey, you can't go to anything she's at, you can't contact people like that, and you can't go to her hearings. Um, that wouldn't keep him out of Gingras's hearings, even though there's a way around that, um, that Gingras could do, unfortunately. It doesn't keep him from going to the courthouse to get public filings and reporting on those. He just maybe can't I mean, the only like, they can't say that he cannot use her name ever. So, I hope it just doesn't get granted, and she's like, "Y'all are grown adults, just stop." But if it gets partially granted, that wouldn't surprise me either, unfortunately. I don't agree with it necessarily, but we'll see how it goes, and waiting a weekend, it's been a long weekend, and nobody has done anything this weekend, and I'm like, "Oh my gosh, I need stuff to watch because 'cause I've had nothing to really I've had other stuff to watch and listen to, but I'm like, "I want more on this." So, alright. Oh, yeah, if you're not yes, if you're not subscribed to Echoes, go subscribe to Echoes from the Tabernacle. He is great, and, like, he's just completely hysterical. He has Jeep Daddy on there a lot, who their banter back and forth is very funny too. So, subscribe, he needs to. I need to go fix my stuff so I can be monetized, um, once again, but I messed up in the back end. Um, alright, let's go to Jingras's blog because why the hell not? Oh, lordy, help me, help me. Look at me, mommy, I'm a real lawyer now. February 22nd, 2026. He has comments turned off, I'm guessing, because I'm sure there would be comments if he allowed them. I love and people on Twitter that disable their comments too. I'm like, "You're such a coward chicken shit." Like, I mean, you can do it. It just shows that you live in an echo chamber and you can't have anybody contradict you. He has filed this under free speech. Oh, Lord. All right. So, yeah, that's the title. I thought when somebody posted that in the chat that it was just somebody saying that in the chat. I didn't realize that was the title of the thing. But here we are. Something incredible happened last week. I'm not sure epiphany is the right word, but what had happened had deeply profounded a profound effect on me to the point it completely, totally changed my perspective about something I thought I understood. What happened? On Friday morning last week, my mom came to watch me in court. That was the first time anyone from my family did that. and it changed everything. Oh, Lord. I hope in the back of her mind, she's thinking, why are you putting everything on the line for this chick? Here's why. I graduated from law school in May of 2000. During the last 25 plus years, I have never had a family member come to court with me. It's not because they don't care. She also lives in a different state. So uh, people are busy and have their own lives, and my family is scattered around the country. I've also done many high profile cases that were covered by the media. And I've done lots of TV interviews, which my parents usually watch. Because of that, no one from my family has ever come to personally observe me in court. They didn't need to. Despite what you think, this seems common among lawyers. I've never heard of any of my lawyer friends talk about having their family come to see them in court. While there's no specific ethical rule against it other than ER 1.6, there's an unwritten rule that says it's usually a bad idea. When a lawyer is in court, the only thing they should be thinking about is doing the best possible job for their client. It doesn't mean that they're not doing their best possible job for their client. Maybe it actually makes them do a better job for their client. And if it's an you can't have an unwritten rule in law. Yeah, it needs to be written. It needs to be a written rule. For the reason it's rare for lawyers to have family watch them in court. I know tons of lawyers. I've never heard of any of them mentioning having mom and dad go watch them in court. Same deal with me until last week. This was not planned. My mom was in town visiting from Florida. She booked the trip months ago before the hearing last week was scheduled on short notice. You decided to take this case when she was coming into town. So I could have let her sit at home for a few hours. Instead, I asked if she would like to finally come watch me do my lawyer thing. And yes, I got my client's consent before I made that offer. You didn't have to get your client's consent, but good for you. I'm sure she's like, oh, I would love to finally meet your mother. I also stopped and thought about whether having family attend would have any impact on the case, good or bad, large or small. Given all the circumstances, I didn't see any issue with it. Nobody's going to bother your mother. Nobody's going to talk to your mother. Might just be like, okay, Jingras had his mom at court. And they might figure out who she is now, but um okay, nobody cares. I assume most people would like to share this sort of take your mom to work experience with their parents. If you play pro baseball, of course your parent is going to come watch you play probably every single game. Our parents raise us, teach us, and help us grow to become successful adults. It's normal and natural for kids to share their interests with their parents. We want to make our parents proud. Okay. But in my case, there was another reason to invite my mom to court. In addition to raising me, she paid for my law degree. Ugh. And if she is not seeing how you are, like, I'd be embarrassed that this is what you've done with your law degree. And she'd be like, "Well, you saw me in my last case ever as a criminal or as not a criminal, but as an attorney, mom. You got to see me in my last lawsuit ever because I was disbarred shortly after this." Hopefully that's the story that happens. In fact, she not only paid every penny of my tuition, she also covered my rent and living expenses for all 3 years of law school. Considering I lived in San Francisco, these costs were not small. The total, including tuition plus rent, was easily more than 200,000 almost 30 years ago. I was one of the only kids in my school to graduate 100% debt free, all thanks to mom. Okay, well, good for her. Like, I'm glad she was able to give you that. I think you've squandered it away. Like, but great, you had Yeah, I thought Rob was gonna speak on this, but I'm sure he was told, "Don't speak on this until after the ruling," because he hasn't, but we shall see. But I think he squandered it away, and I don't the way David is, I feel like maybe she's not the type of mom that would call him out on his BS. Um, like that she just blindly supports him in everything he does because I'm just not that kind of mom. Mom's generosity is why I frequently help people at no charge, but you're asking for attorney's fees. So I've done this numerous times during my career. I've handled entire cases for clients at no charge. It's not because I'm a loser who can't get real paying clients. It's because I feel so much gratitude for the incredible gift my mom gave me. I feel I owe a debt to the world that I try to repay by giving free legal services to those in need, something my mom supports. I'm sure she does support that. But what I'm sure she doesn't support is you throwing your whole entire career and everything that she paid for with her hard-earned money and that you worked for in law, your, law school, that you squandered away on this chick and that you're doing it for free, everything that she needs you for. Like, taking her case originally, fine. But everything else you've done with taking the case, and then you've tried to get in on everything else pretty much, your mother has got to be thinking, "Why the hell is this person so special?" I thought having my mom come watch me in court would be a moment of pride. Finally, I could show I took her gift seriously. Yes, I wanted to make her proud, but I also wanted to show her the 200K gift she gave me wasn't wasted. No, it has been wasted. It was money well spent. No, it wasn't, because you've squandered it away. But after the hearing ended, something unexpectedly happened. I went home, took off my suit, and I went out for my daily 5.5 mile walk. Okay, why do we need to know that? And decompressed. I started to replay the events of the day. I thought about what happened in court, and I noticed something. Dun, dun, dun. When I do hearings like this, I always get insane tunnel vision. Always, every time. I also completely focused on work. I tune everything else out that happened around me. A bomb could go off behind me and I'd never know it. I argued cases in front of packed courtrooms, but to me, the room feels empty. Yeah, because you think you're the most important person there. When I'm in a moment, everything else fades into the background to the point where I'm completely aware of anything else but my client or whoever is on the stand. There is literally a tunnel going from my face to the witness on the stand. Nothing else exists outside of that tunnel. Well, that's a lie because you wouldn't be objecting to questions if if everything else didn't matter except for the witness on the stand. Because that would mean you'd have to tune the lawyer out and you object. So no, it's not a true statement in the literal sense if we're getting technical. Except on Friday. On Friday, as I stood there asking questions and talking to a judge, I was not standing in an empty room. I stood there with full awareness that my mom was sitting 10 feet behind me. Okay. This wasn't just any random spectator, like the tattoo covered lady who furiously scribbled notes. Okay. Well, I don't know who that is, but go on with your bad self, Miss Tattooed Lady. This was the woman who gave birth to me, the woman who packed my lunch when I nervously walked off to my first day of kindergarten. Yes, I walked in to kindergarten because our house was across the street for school. The woman who threw every single birthday party, wrapped every Christmas present. This was the woman who went back to work, started a company, sold it, and then gave me this money so that I could get a law degree. My mom was and is still a rock star. She sounds like an amazing lady, Gingras. I will give you that. She sounds amazing. I don't know why you sure turned out to be such a turd. After all her success and achievement, I finally got to show her some of my skills. Folks, let me tell you why this is simple event shook me so much. I previously commented about a certain judge who allowed her father to secretly attend an extremely high profile trial. When I criticized the judge at the time, my concerns were not primarily focused on her father being present. Trials are public proceedings. People are allowed to come and watch them. No big deal, right? Because of that, my criticism was mainly focused elsewhere, not just on her dad being there. At the time I said those things about Judge Mata, no one from my family had ever come to watch me in court because I never had that experience. You don't have to have that experience to not be a douchebag about things. I didn't know how it felt to have a parent sitting there watching me live, so my comments about the judge were based morely on my assumptions about what I thought that experience might be like. Now that it happened, this was completely changed my mind. In fact, I will confess, I was completely wrong. In what way? In this way. I said before there was nothing inherently wrong with the judge allowing her father to attend a high profile trial now that I've had my mom in court with me. I can see my perspective was 100% wrong. It is absolutely improper. It is absolutely improper for a judge to do this, at least in this situation. What? Here are the two reasons. Okay. Well, maybe you and her are not in the same position. First, when I was standing there in court, I could feel my mother's eyes staring in the back of my head. The woman paid a huge sum of money that allowed me to get a law degree so I could have privilege of being a lawyer. Well, maybe Judge Mata's dad didn't pay for her schooling. So maybe you're not in the same boat there. I also love her to the moon and all. Of course, impressing her mattered. It added pressure it wouldn't normally feel. And she saw Laura on the stand. This woman that you have been throwing your life away for. She saw her on the stand. Although I'm sure the narrative y'all have fed her about, oh, this dude said things about her. And she doesn't have the full story about this lady. She could look it up, but I'm sure she doesn't have the full context. Knowing she was there, I felt different about every word I said, every move on my hand, every gesture, every comment. They all had to be perfect. That's your problem. Judge Mata may not feel like that. Because her being a judge is just her sitting there and listening and making calls. It's different than her lawyering. Um, Also, her dad wasn't in the courtroom. He was in an overflow room where Judge Mata couldn't even see him. She might not have even known he was there. Maybe she did, but he didn't go sit in the courtroom. And so maybe that's why he sat in the overflow room. It was like, I was 100% wrong. Because before I thought it was just maybe weird. Now I'm saying it's absolutely improper. So he's doubling down, basically, is what he's doing. Oh, I'm sure his mom knows about Laura. I'm sure his mom knows all about Laura because he probably tells her about cases and how this mob is attacking him online, as he says. Yeah, I agree. I don't know if it was it secretly. Was it secret to anybody? Was it a secret to Mata, or did Mata and her dad scheme this up? Like, this is more speculation, as Bruce says. There's no proof of this. And maybe he likes to go watch his daughter. and he could do it without being in the courtroom and maybe making her nervous, so he sat in the overflow room so that he wasn't in the courtroom making her nervous or something like that. It's so ridiculous. So is he saying he was off his game? Off his game because right, is it tunnel vision like when he was drunk driving at night with the red and blue lights flashing at the end of the tunnel? It just it seems like you had to be perfect, it says, so didn't it actually make you be a better lawyer for your client than when she wasn't there? So wouldn't Judge Mata be trying to be a better judge than if she like, this doesn't make any sense. Yeah, maybe her dad has watched her several times. Maybe they practiced together before she became a judge, and so her dad's seen her do it a bunch. I don't know. I don't even know if her dad is a lawyer, but it doesn't mean that your experience is the same as everybody else's because nobody seems to experience life the way that you and Laura do. Nobody. Let's see. It wasn't enough to just do a decent job. It wasn't enough to me to be competent. I had to be at my very best. I had to be remarkable, outstanding lawyer who made my mom proud. And what if your lawyering that you did your very best, perfect, everything like that wasn't good enough and you still lose this argument that you had on Friday? Was it perfect? Was it good enough? Were you remarkable and outstanding? If you lose the arguments, this was the woman who made my biggest dream possible. But I thought you didn't care about being a lawyer anymore, especially in Arizona. You just don't care about it anymore. It's not what you wanted to be doing. How could I not be affected by her sitting there? Of course, I was not there as a judge. I had no power to rule in favor of one side or the other. So, in that regard, my mother's presence did not and could not have changed the outcome of the case in any way. That's why I think it was fine ethically for her to be there. Well, see, that's grand and all. But the thing is you voiced your concerns to higher up courts and they find your client for bringing up stupid shit that were not based in facts or law. So, no matter what your opinion is here, the appellate courts don't agree with you. Nobody agrees with you. So, your opinion is not very good. A totally different rule should apply to judges. Their role is not to be an advocate for a client. How is having a judge there an advocate for anybody? Their role is to judge and do so neutrally, blindly, and dispassionately. Their job is to ignore everything except for the facts and weigh the law. That awesome power carries a duty and responsibility that far outweighs any right of a parent to come and watch the proceeding and cheer on their child. He was not cheering on his child. Going to watch your child does not mean that you're causing a scene. That is my opinion, but it's not just speculation. Yes, it is. I have acted in a judicial capacity many times in the past. I have worked as an arbitrator both for the Superior Court and for the State Bar of Arizona. Yeah, they probably want to look at all those cases that you did for the State Bar. I have worked okay, you said that. As an arbitrator, I have presided over hearings in basically the same way a judge does. I have been given the incredible power of making decisions in favor of one party and against another. I have ordered people to pay money sometimes, and I have rejected claims as groundless at other times. I've seen lawyers do this It happens. Those rulings directly impacted the lives and the parties. I was extremely aware of that every time I acted as an arbitrator. If you've never done this, trust me, you can feel the weight of the job. I get it. Um, I well, it's being removed, but I just watched Franklin and Bash um, on Netflix, and I binged watched it so because it was leaving at the end of February, and in one of the episodes, um, Franklin, who is Breckin Meyer's character in Franklin and Bash, has to go be a judge for a day, basically, and he didn't like it because while he is a lawyer and is up to antics all the time, him and Bash are up to antics all the time, there was some rulings that he didn't wanna make, but he had to make, and and it is different, but I don't see how having somebody come watch you is any different. I mean, to me, it's no different than having your boss come and watch you. That's more nerve-wracking than anything else. Knowing this, I have now completely changed my view. A judge should never ever be allowed to have a family member come and watch a profile trial, never, not under any circumstances ever. Okay, well the thing is if it's a high profile trial, what if it's a low profile trial? Can they come then? Cuz why does it matter? Also, if their kid is a judge and it is live streamed, they get to watch their kid in trial on a high profile trial. They get to watch from the comfort of their home if they want to. So, no, this is not the way of the future, Gingras. Their lawyers do get to play arbiter. Um, there are times, especially in like family court, if they have like a full docket, they're allowed to see or hear some matters. This is ridiculous. It is just too perilous, and it presents too great a threat to our legal system because it severely undermines confidence in the judicial system. Again, I understand that if a judge rules in the favor of one side you already support, you probably don't care. But what about the losing party? Is it really fair to just let them wonder? Did I lose because the law or the facts required it? Or did I lose because the judge was trying to impress her parent? Well, the appeals court told you why you lost. So this is where the checks and the balances come in our justice system, right? Is that you took this to higher up and they do not believe your arguments are based in law or fact. They're not based in reality. They're based on your little del Delulu world that you live in. It's just so ridiculous. And if so, did I lose because of the law or the facts required it, or did I lose because the judge was trying to impress their parent? Well, this is why you're allowed to have appeals. And so if the judge didn't decided that you lost and it wasn't based on laws or facts, then the appeals court would have said so. But the appeals court didn't give a shit about your argument. No one should ever ask that question. Our justice system is not a reality TV show and it's not a sporting event. David doesn't want transparency in the courtroom. That's what I think. Doubts over judicial neutrality and integrity have no place in our legal system. That's not my view. That's literally written into the Code of Jurisdictional Conduct. And none of this fucking matters because you got to appeal on this issue and they did not agree with you. Take it to the Supreme Court. Go try to do it there. They're not going to agree with you either, in my opinion. There's there is nothing about a person's parent being there that shows a biased or the appearance of a biased. It doesn't do anything. Like, it shows nothing. And you don't know if they would be biased towards you or not towards you. Like, it's so dumb that you're arguing this. See that line, a judge must avoid impropriety. Simple, but that's not enough. Public confidence is in the neutrality of judges is so important. It's not enough for a judge to just avoid actual impropriety. They must go further and avoid anything. Yes, they cannot appear to be that. Go look at the Karen Reed trial. Go look at the Edric Faust trial. If you want to talk about the appearance of impropriety, go look at those cases. This is not the case for that. That's why I stand by my previous comment about Judge Mata. If anything, knowing what I know now, my comments did not go far enough. So you're doubling down on what you said to a judge that you are in trouble with, possibly with the State Bar of Arizona. You're now doubling down on this and rubber stamping again. You're look at me, daddy. I'm a real lawyer now. Tee-hee. How fucking dumb can you be? She engaged in actual impropriety by talking to her father about the case. Something she doesn't have to deny or accept it. She didn't have to answer your questions. She's not there to answer questions. You talked to other people about it. Nobody else agreed with you. She also engaged in, and you do not know that she talked to her father about this case. Her father could have just heard about it from other people. She also engaged in conduct that rises an appearance of impropriety by allowing her father to secretly attend. You don't know that he secretly attended. Did you tell people that your mother was there? Did you tell Hey Rob's side that your mom was there so that he could object if he needed to or if he cared? Because I'd like to know that too. Oh, she didn't let us know so that we could raise objections. It's a public hearing. And I would like to know if you let people know that your mama was there so that Hey Rob could possibly object. Note, although I still believe Judge Mata engaged in other misconduct like reviewing social media, I have a whole video on why Gingras let Mata read comments on his blog. He put it in a court filing and cited it. So if she clicks on it, she can go see it. He put it in a court filing. She didn't have to go looking for it. I've come up with a new theory about how she reached the conclusion on Planned Parenthood being closed on Sunday. I previously said I believe she must have gotten the information from social, but perhaps it's comments posted on my blog. I think at one point I also mentioned other possibilities like her sister telling her, or maybe a member of her staff. I have a whole video on it. So if he's watched my video, it's from your blog post, in my opinion. And you put it in a motion to cite. So you gave her that information actually that you're contesting. With the benefit of more time and reflection, I have reached a new conclusion about what probably happened. Her father attended the trial, but he did not sit in court. Wonder why not? Instead, he sat in the overflow room, although he apparently also chatted with multiple people in the hallway. Oh my God, he chatted with people in public who didn't know who he was at the time. It wasn't in the overflow room, but I'm going to make a guess. I bet people in the room were on their phones during hearing, looking at Discord or Twitter or whatever. My guess is that someone in the crowd saw a comment about Planned Parenthood is closed on Sunday. That person told someone else, look at what they just said on Twitter. Planned Parenthood is closed on Sunday. Judge Mata's dad overheard the discussion. Dad then shared that information with his daughter after the trial, and that's how that information got its final ruling. Again, to be clear, I don't know it for a fact. Exactly. Because there's actually a logical and legal reason for her to have that information and her to have made a clerical error, as you said Laura did. She miscited where she got that from, just like Laura did in her injunction against harassment case. So stupid. Based on a hunch. But that's why I'm going to ask Judge Mata and her dad to answer questions under oath to see if that theory is correct. I'll bet you dollars to donuts that it is. Okay. I guess good for you. You have a deposition with Judge Mata and her father. If that's what happened, it means my initial theory was wrong, but that doesn't change a thing. I'm allowed to be wrong. The rule doesn't punish lawyers for having a hunch. It can only be punished for saying things I knew were false or which I said were with actual malice, meaning I had a high degree of awareness that what she said was false. You putting nasty things about look at me, daddy, that's your actual malice. That shows actual malice right there. You dumb fricker. Oh, wait, hold on. What is happening in chat? Didn't he basically say as much in the Christmas video they did? I'm fairly sure he said. If she said, she might have said that worst bachelor ever has been awful to this girl and heard the evidence. Oh, right. Yeah, I know you can ask for fees if you're not. I'm just saying you shouldn't be allowed to because especially when he wants to put he's doing it out of the kindness of his heart. Yes, it would be. She needs to go watch tax videos. She needs to go find out what happens if she's in prison. Like, there's a lot of things that she needs to be doing to get her into reality, not watching us. I don't know if she listens or not. In any event, I understand certain fans of a TV show don't care how the court reached its result. It did. You don't care if the rules were followed. You don't care if the law was broken. You only care about the outcome. That is not true. Because where I think Alec Murdaugh is guilty, I absolutely think because of Courthouse Becky making comments to the jurors that Alex Murdaugh absolutely deserves a new trial because of the shenanigans that she pulled. I like that he was found guilty. I don't want them to have to do it again. But I do believe that he deserves a new trial. Just like I want Laura to have good representation. I want her to be able to put on whatever defense she wants to put on. I want things to be fair and I want there to be receipts because just like I want murderers to have fair trials because I do not want an appeal on some legal technicality to have these murderers and stuff like that back out on the street. So, no, you're wrong about this shit. We do care about the law being broken. We don't only care about the outcome. Some people might. I don't. But that's what you think. Now that I've had the privilege of letting my mom come to court with me, I know my decision to criticize Mama was not only correct, it was mandatory in my role as an officer. You could have criticized with you could have done constructive criticism. You didn't need to do it in the manner that you did it. You could have done it in a better way. You can be displeased with Mata and not like it. And you can say you don't like it. But it's the way you went about it that people have a problem with. Nobody says you can't like a judge and their rulings. It's the way you did it. My duty includes an obligation to report misconduct by anyone involved in the system, even judges, especially judges. And I take that duty seriously and I stand by every word I said. And yes, my mom was proud. That's because she only knows what you tell her, and you're not telling her the whole story. P.S. Since I'm always falsely labeled a misogynist who hates all women, let me say this. I mean, maybe somebody has labeled him a misogynist. I don't know. I don't think he hates all women. I think he loves himself more than anybody else. But he says, I think the Judge Coates was excellent. She was friendly, polite, helpful, and she seemed to be listening very carefully. She gave us extra time and seemed to go overboard to let both sides say everything they need to cover. Obviously, I hope she rules in our favor, but even if she does not, I will respect her decision and won't question that we were given a fair hearing with a fair judge. Felt good for a change. FYI, she isn't a judge, she's a commissioner. The position is kind of like a baby judge or maybe judge in training. That's not a derogatory term. Lawyers who want to become judges normally apply to serve as commissioners, like Commissioner Duty. Commissioner Duty was a joke. This gives them the experience and a chance to show they can do the job. Mata was a commissioner for 7 years before she became a judge. Great. Why was Judge Duty in that role? Because he was retired and still wanted to judge things or do legal work? He wasn't a Judge Duty definitely was not a baby lawyer trying to become a judge. Also, I didn't realize this, but I found a post that said Commissioner Coates worked for the county attorney's office for 9 years. I assume that means she was former prosecutor, bearing in mind the county attorney's office also deals with civil issues. Okay, great. You like her now. We'll see what her ruling is and what she puts in her ruling. Right now, he's nice to her. But if she says one wrong thing in her writing, he's going after her. I don't think he is I don't think he's misandrous. I don't think he's misogynistic. I think he only likes people that agree with him, no matter what your sex is. And because yeah, he can say misogynistic things. Like he says misogynistic things, but that's his low below the belt way of just doing like ad hominem attacks on people because he says bad things about men too. So he's just an asshole and he's hateful to anybody that doesn't agree with his stance on things. He thinks that he probably thinks all Republicans are bad because he doesn't like Trump. Well, that's you can't say that. just and so he's just a jackass. Yeah, as Henrietta says. Yeah, I think he just likes to hit below the belt and say things that are offensive, and so they sound misogynistic because there's not I mean, there is men in this thing, but, um, but he also I just don't think he's as I don't know, he doesn't I don't know, like, I just yeah, I don't know, I just think he's a jackass and hates everybody, um, that doesn't agree with him on anything. I don't think people can have actual debates with him because of how he is. Yeah, impulsive lashing out, yeah. Which is weird that he talks about, "Oh, I'm better in oral arguments," which he is better for oral arguments, and I think that's why he asks for them, but his writing is just vomiting words. And it should be the opposite because most people, like, they say stuff, but if they're writing something because you can, like, take a moment and read it and think about it, your writings usually aren't as bad as maybe something you just say in spur of the moment without thinking. And if he can hold back his speech and not say things when he's talking verbally, he should be able to do the same thing in his writing. And so he chooses not to. And I just don't like most of his stuff are just not legal. They're opinions, okay. I also wrote a blog about why he was actually banned from YouTube and their terms of service and stuff like that, which whatever. I don't want him on YouTube, but it is funny how he got banned. And he thinks Borat doesn't have nudity in it, apparently, which I'm like, have you maybe you need to go back and rewatch Borat because Borat definitely does have there's a whole scene in Borat that I have to fast forward through all the time because it's disgusting and I don't wanna see it. Has anybody seen Borat? Know what scene that might be that I'm just like, "Absolutely not. Mm-mm. Nope, that's gross." Borat is a funny movie, though. My brother and I quote things from there all the time. It's got great one-liners. But that is it, and hopefully we will get the ruling tomorrow, on Hey Rob's case, but I wanted to get this done before. Um, yeah, there's just a scene that I'm just like, "Mm-mm, nope." But I get uncomfortable in different scenes, even if they're in movies, so I'm like, "I don't think I need to be here for this." So, but I hope y'all have a good evening, get some rest, or good morning, when you watch this, and I will see you guys soon. Good night.